Hi, everyone. This is Raquel.
Hi, and this is Jennifer.
Welcome to Madness Cafe.
This is a feminist podcast where we talk about women's issues, politics, and health and wellness.
And where those issues intersect. Hey, everybody. Welcome back to Madness Cafe. Today, Jennifer and I are having a discussion that I have been wanting to have for so long, since when we first started talking about creating the podcast. We are going to talk about the U.S. Supreme Court and all of its nonsense, for lack of a better word. We have a guest with us today who is talking to us about this. Her camera is not on, but she's there, people. Jennifer and I are not just talking to the ether. Let me introduce our guest today. Her name is Tonja Jacobi. She is a professor of law and Sam Nunn Chair in Ethics and Professionalism at Emory Law School. She has a Ph.D. in political science from Stanford University, a master's from the University of California, Berkeley, and a law degree with first-class honors from the Australian National University. Professor Jacobi specializes in Supreme Court judicial behavior and public law. Her areas of interest include judicial politics, Supreme Court oral arguments, constitutional criminal procedure, legislative process, and constitutional law. Combining doctrinal, empirical, and formal analysis, Professor Jacobi examines how judges respond to institutional constraints. In particular, she is a renowned expert in Supreme Court oral argument. In a series of empirical studies covering 60 years of arguments, she has identified patterns and prejudices in judicial and advocate behavior, and has shown that case outcomes can be predicted based on those behaviors. Supreme Court justices have commented on this work and said it changed the court. She is published in over 60 peer review and law review journals. She also regularly writes Op Eds in major periodicals such as the New York Times and the Washington Post, and has a regular column in Bloomberg Law, Questions Presented, which examines thorny issues facing the U.S. Supreme Court and ethics in the legal profession. She has multiple forthcoming law review articles on judicial behavior and criminal procedure. This woman knows what she is talking about. Y'all, we are so excited to have Professor Jacobi with us. Professor, thank you so much for being with us to talk about the U.S. Supreme Court. You are definitely somebody who is qualified to talk about this topic. Thank you for being here.
Thank you so much for having me. And I want to say I'm really excited to be here. I'm sorry I can't have my video on. It'll give me a migraine, but I hope everybody can feel in my voice that I'm really happy to be here.
Oh, thank you so much. And no, we don't want you to have a migraine. So no worries about your camera being off. That's totally fine.
So I guess we just wanted to start today asking you a little bit about you and how did you get started in this work?
So I was studying back in Australia. I'm from Australia, and I was studying law. In Australia, we have a strange system where you start off your law degree at the same time as your undergraduate degree, and then you do 2 years graduate. So it's a little bit of a mix. It's not like the English system where law is an undergraduate degree. It's a semi-graduate degree. Anyway, so I was already reading Australian law cases, and then I started studying American politics. And in particular, I got interested in American judicial politics. I would read American Supreme Court decisions. And as much as I love to tell my law students this, they were very easy to read compared to Australian decisions. And I realized that this was reflective of the different political system that each court is operating within and the ways in which each court is political and apolitical. And so we can see that the Supreme Court generally has joint opinions. So there's an agreement as to who's going to write the opinion, and the process, the political process of sort of strategizing as to what that opinion is going to look like involves compromise, and so opinions are written in a much simpler way. Whereas in Australia, every justice just writes their own opinion and they can say whatever they want and be as esoteric as they want. And I got really interested in the way that the court is part of the political system and how that affects judicial behavior. And that's still what I'm doing now, 30 years later. I came to the US to do a PhD in political science. But then I wanted to teach at a law school and be surrounded by other people who wanted to talk about the courts. Essentially, my research is still doing the same kind of thing, looking at the political nature of judicial behavior in the US. Occasionally, I do a little bit of work on Australia, but most of my work is on US Supreme Court justices.
Fantastic.
Well, definitely they've given you a lot to write about in the last few years.
Yes.
But before we dive into the nonsense that is going on with the court as far as the justices personally and how that's affecting politics and all of our civil rights, can we talk a little bit about, there's two things that always kind of sit front of mind for me with the Supreme Court. Why are the justices appointed for a lifetime? And what's the opposition to term limits? Can we talk about that a little bit?
Sure, that's a great question. And it's certainly not true that every apex court is like that. So Australia, for example, the justices have a mandatory retirement age of 70 or a maximum of 20 years on the court, whichever occurs first. So the maximum amount of time you can serve is 20 years, which is a pretty long time to be shaping, major areas of law throughout the nation. And it also means that people are a little less out of touch, a little bit more representative, a little bit more diverse. And I think it makes for a really much better system. Here we have the fact that people are appointed for life causes all sorts of strategic behavior by the justices that's really not great. One is that you can actually predict who's going to die based on which political party is in power. So a justice essentially will hang on. If their political party is out of power, they will hang on and they'll be more likely to die on the court because they're just waiting till they can have a person like them appoint the next justice. And that's pretty extreme politics when you think about it. Yeah, and originally they wanted to, the founders, when they wrote the Constitution, they wanted to protect the court. They saw the court as very weak. And so one of the protections that they gave was life tenure. Now, it's a good idea to have tenure, but not necessarily life tenure. And, they were making these decisions, pretty much without precedent. And it would be surprising if they got everything perfect. The problem is that we don't really update the Constitution much. And so there's this resistance to term limits because it would require a constitutional change. And that's been traditionally very hard to do in the US. Certainly as a policy matter, I don't think people would design this way now. So we see younger and younger people being appointed to the court. People used to serve for about 18 years. Now they're serving 40 years in some cases. So.
Right. Well, and people who are being appointed at such a young age that honestly, and in my humble opinion, don't have the life experience, the judicial experience, the professional experience to be on such a high court.
Yeah, now we have 8 of the 9 justices were former judges. And that is so that the body, the national coalition that appoints the justices can be confident that they're going to get exactly what they want. So there are no more surprises. Back in the day, we used to have, quite surprising outcomes where, a Republican administration would appoint a justice who turned out to be, reasonably liberal and vice versa. We don't have that anymore because there's this real political litmus test. And the easiest way to do that is to appoint a prior judge. And so there's pressure to appoint lower court judges at a younger age as well. And there's not this same diversity. Like we used to have, ex-presidents, ex-senators being on the court, a diversity of experience, and we don't have that anymore.
Well, I think that's just one example of how the court has changed over time. One of my other questions, which thankfully you just kind of gave me a jumping off point for, is the way that the court has changed. And how has it changed more so in recent years? Not just that there's younger justices, but maybe some other changes, maybe lack of standards, lack of ethical behavior, the politicization of the institution. Can you talk about some of that a little bit?
A couple of different things. The ethical standards, remind me to come back to that at the end, because that's a much more recent phenomena. But to put it in a broader context, so I wrote an article talking about justices as advocates. And I do a lot of empirical work on Supreme Court oral argument. And the reason I study that is it's the one transparent part of the judicial decision-making process. Everything else is done behind closed doors, but oral argument, the public can actually listen to oral argument. They can't watch it, but they can listen and see the sorts of questions and discussions that the justices are posing and having. And so I did a big project on that, looking at how oral arguments changed over the decades. And I had a theory that as the country has become more politicized, as the parties have become further apart and more extreme, which really started particularly starting in 1995 was when the biggest change happened after the 1994 Republican Revolution in Congress. And we saw big changes in Congress where moderates just disappeared, and we had this really bimodal distribution ideologically within Congress, and that filtered down to public attitudes such that people are more likely to see people of the other political party as, bad people with evil intent. I wanted to see if that changed the behavior at the Supreme Court, and I hypothesized that it would. And sure enough, what we see is really different behavior by the justices starting to change a lot from about 1995. And so the justices, oral argument has traditionally been 1 hour, quite strictly. And since 1995, the justices were using up almost 25% more airtime than they had before. So 13 more minutes in addition to what they were saying before. And not any more questions are being asked. They are using that entire additional time that's at the cost of the advocates to make comments and to present conclusions and arguments rather than to question the advocates. The whole purpose of oral argument is that the advocates come before the justices and they try to convince them of the side that they're representing. And what I was showing is that more and more the justices come in with set ideas, they argue them, they advocate for particular positions. And so you can actually predict how the justices are going to subsequently vote in the case that they are supposed to be considering at the moment, based on things like which side they talk more to. They use up more time of the side that they vote against, but they also direct their questions to the side that they ultimately support, and they make comments to the side that they're actually going to vote against. You can use other predictors as well, such as who they interrupt more. That's whoever they're going to vote against, they interrupt much more. And also even jokes. If you look at, I did a whole paper on laughter at the court and showed that it's not this sort of equalizing force that, that somehow dissipates tension. It's actually a mechanism of advocacy, and that the justices use it against parties who they're going to vote against personally, those who are losing before the whole court, and the most inexperienced advocates. So it's kind of a way of establishing their superiority, but also acting as advocates. And so there's much more of a role of the justices now to come and argue for a position that is already predetermined rather than, being open to argument. And so that's one of the biggest changes. And I think the politicization that we see within the nation is really affecting the court as well. And then coming back to the other part of your question about the ethics, there's been a lot of controversy, as I'm sure many of your listeners know, in just the last year or so, where it's come to light. So that Justice Thomas in particular, but also in some instances, Justice Alito and Justice Gorsuch, have engaged in pretty ethically dubious behavior, such as taking massive gifts from people with interest before the court, which is really ethically very, very problematic. So Justice Thomas, for example, has taken something like 26 vacations at the expense of Republican donors who often have cases before the court. And we're talking private jets, we're talking yacht cruises. He even got a loan, which I don't think was ever paid back, for a $250,000 RV. Things that are really, even his adopted son's school fees being paid, private school fees, things
his
like
mother's
that.
House.
Yes, his mother's house being renovated, and she's living in it for free. Just really quite shocking ethical violations. And the funny thing is, Justice Thomas, likes to present himself as a strict law and order type, but also a strict constructionist of the law. So he'll read the text to say what it says, regardless of outcome, and be very harsh on, criminal defendants and so on. And then when all this came out, he was like, "Oh, well, I didn't understand the form, and you have to forgive me because I was confused and I got advice from people." And this sort of
such a liar.
He would not tolerate from anyone else.
Not at all.
The hypocrisy was pretty extreme, and it's still ongoing. And I don't think there's much Thomas could do to actually get impeached by the current Congress.
I'm sorry, I know I'm interrupting, but I tell you, this whole thing just chaps my ass. So, is there nothing that can be done to Thomas and Alito for these egregious ethical violations?
There are things that could be done. It's pretty clear Thomas has broken the law. I mean, there could be legal repercussions, but nobody's going to bring that case. I mean, he could be censured, he could be impeached. I mean, it's pretty clear that he has for decades now been just flouting laws just to report what he's been taking, not even to say you can't take these gifts, but at least you have to have transparency so that the public knows. And he's just been disregarding those laws. And the violations by Alito and Gorsuch are much more borderline. But they're pretty damning as well. I mean, and Alito's defense to the gifts he was receiving was, well, he doesn't think that the wine that was provided to him cost more than $1,000 a bottle, because otherwise he would have remembered it. Just the tin ear that is displayed by these privileged men.
Yeah.
Well, what's kind of confusing to me is you said no one will bring it forward. No one will bring it forward. I'm still really confused about why, when President Obama was in office, he could not pick a Supreme Court justice. Why don't the Democrats, why do they seem to act like their hands are tied and they can't do anything in these situations? Why isn't there action? Somebody should be like,
somebody needs to do something.
Yeah. Why does it seem like both sides are happy is not the right word, but why is everyone putting up with it?
Well, so in relation to Obama's nominee in particular, the Republicans just would not even meet with him. It was a year before the election, and they said, "Oh, it's too soon before the election." They came up with these excuses. It was too close before the election. And then when Ruth Bader Ginsburg died, they appointed Amy Coney Barrett 3 days, before the election, or something like that.
And how does that happen? How does there one thing apply and then something completely different?
I mean, it's just raw political power. So while the Republicans controlled the Senate, Obama's nominee of Merrick Garland was going to go nowhere. No matter, it wasn't about the quality of his candidacy, that the Republicans had actually been supporting his candidacy when they thought that they had to compromise. Then as soon as they realized that they could just hold out for a year, they didn't feel any compunction to actually act to follow the constitutional system. Now, when the Democrats gained power, they had a very thin margin of power. They really needed to keep Senator Manchin on side in particular, and also Senator Sinema. And they just weren't willing to play ball in the same, there was a big debate, not so much about judicial nominees to the Supreme Court, because there's no filibuster there anymore, but there was a big debate about whether to get rid of the filibuster and to get legislation passed and to do all the things that the Democrats had been waiting to do for the last 4 years during the Trump administration. And, Manchin he's from a very right-wing blue state. So it was he was in an untenable position. And I actually wrote an op-ed around that time saying, we might dislike Manchin for refusing to get rid of the filibuster, but who we really need to put pressure on are Republicans who claim to be much more moderate, like, Mitt Romney, for example, and say, do you actually believe in the democratic process? Susan Collins of Maine, for example, and put pressure on them to think about what sort of system we want. I mean, the counter-majoritarian elements we have, such as the filibuster, just give power to small minorities, which has traditionally been used. The main thing the filibuster was used for was to stop civil rights legislation being passed. That is its history. And so this idea that, we don't want to mess with tradition, I'm getting a little off topic here, but it does sort of all tie into the same idea of, there's no real constituency for a proper functioning democratic system. And we see that in terms of court decisions and legislation that fails to pass. I mean, the democratic institutions are being undermined by the current court, and nothing's being done about it. And it becomes a catch-22. It's very hard to democratically change an unequal playing field in the first place.
In one of your pieces from the BloombergLaw.com, you write about examples of the court choosing to fundamentally change the constitutional landscape of the United States. For instance, ending affirmative action, ending Roe v. Wade, rolling back civil rights. I think I am flustered. It's probably a weak word for this, but so flustered at why things like that are being allowed to happen when it's clear that it's a minority of people who wanted those things to happen.
Yeah.
And regardless, I mean, for the first time in the court's history, they are taking rights away from people.
That's right. Yeah. This is a radical court. Sorry, I didn't mean to interrupt.
Yeah. Oh, no. Go right ahead.
We're in
I'm
furious
just
agreement.
screaming at the mouth at this point.
Yeah. I mean, the Dobbs decision overruling Roe v. Wade was so radical in so many different ways. So it was the first time that a recognized constitutional right was taken away from people. Women had had that right for almost 50 years. People had structured their lives around the idea that they controlled their bodies and they had reproductive freedom. It had massively changed women's ability to participate in the economy, to have careers, to have choice over lifestyle. And that was taken away by the court. And it grossly does not represent a majority of most people's views. Most people support a fairly reasonable degree of reproductive freedom rights. So that's the first thing. That was just completely radical to do that. Right. The second thing is that they also, at the same time, it doesn't get as much attention, but as well as overturning Roe v. Wade, the court overturned the Casey case. And Casey laid out the unusual circumstances in which cases could be overturned. So it was a case about when you can overturn precedent, essentially. Casey set out a bunch of considerations that you take into account, like have people relied on this right, or have the facts which justified the original ruling just completely changed. And none of those applied. And so because they didn't apply, they just abolished the rule and they didn't replace it with anything else. So now there's this sort of lawlessness by the Supreme Court in that we don't know when long-standing precedent is going to apply. So the court can just basically make up what rule is going to apply in any case according to which party they prefer or which outcome they prefer. And so we see this incredible selectivity in the way even the Constitution is protected by the court. Some rights are being protected. So rights to religious freedom, gun rights, etc., are being strongly protected by this court. But things like reproductive rights, but also criminal defendants' rights, equality rights, freedom from discrimination, those rights are not being recognized at all. And so there's this sense, there's complete lack of constraint now. And it's quite radical, some of the decisions that the court is making. So it's reaching out. So the affirmative action case, for example, that you mentioned, now people are very divided on the issue of affirmative action. It's controversial, but the Supreme Court took that case and reached beyond the confines of the case to decide that essentially, race cannot be considered in university admissions across the country, with one tiny little exception, in a case that just didn't really raise that question. I mean, Harvard had a pretty discriminatory approach. It was essentially, excluding Asian students at a pretty obvious rate. So it could have easily been decided on that basis. Like, you can't discriminate in this way, but rather than doing that more sort of narrow decision as is appropriate in constitutional interpretation, they just said across the board, this can't be done. And so they were reaching out for the most controversial rule they could think of because they just felt completely unconstrained. And so your question was why can they get away with this? And I think because the structures of power are such that they are, at the same time as they're making these substantive decisions that are, really not reflective of the people's will, they're making decisions to stop basic mechanisms of the democratic process working as well. So it's very hard for the majority's views to be represented either at the court, but also through the political process. So, they are essentially allowing radical gerrymandering such that politicians essentially choose their voters rather than the other way around. They're allowing all sorts of voter restrictions that weren't allowed. The voting, they essentially made a major part of the Voting Rights Act non-operative. As soon as they did that, like, all of the states that were affected passed these very restrictive voting rules that have massively affected minority participation in elections. They're immunizing themselves from response by making it very difficult to have a democratic response. So it's quite clever.
Well, and diabolical might be another word for it, but
your word.
Well, yeah, I fully own that. In light of a radicalized, politicized Supreme Court, what can be done to regain the rights that we've lost, protect the rights that are in danger, and protect democracy?
That
do
is
we have to wait for all? I know it's a big ask.
Big question, Raquel.
But do we just have to wait for all of these people to die?
No, I don't think that that's actually a very good answer, because this is power self-perpetuating, and so I think we can't wait. I think what we need to do is get out and vote now while we still have some voting power, and make it clear that things like these massive restrictions on reproductive rights, which, by the way, don't just affect people who want to have an abortion, like women across the board, their lives are being threatened by rules restricting what doctors can do. Pregnant people are dying because of these rules. That's not a bug, that's a feature. Women need to vote as women. Women typically don't. Like, they don't vote on gender issues. So, people should be out there voting on the basis of Dobbs, because your lives and your daughter's lives are going to be in danger from that. People need to organize such that, even though you may need to get 55% of the vote rather than 50% of the vote plus one, voting is really the only way to change this. And if there's a groundswell and then a reaction against this court extremism, but the longer we wait, we can't just wait for these people to die, or for younger and more representative people to be appointed, because they're not going to be appointing more representative people unless who is in Congress changes. The power to vote is really, and to organize and help other people vote, is really the only way things are going to change. It's not a coincidence that a lot of these rules make it harder to organize and harder to for votes to actually matter.
Right.
So in regard to the voting, a lot of people don't show up unless it's a national election year. Where should people start with voting? Is the school board important? Is city council important? Or are we talking about judges? Like, where should people start?
That's a great question. I mean, for a long time, I think the Democrats have really been focused on the national elections, the presidential and congressional elections, and I think ignoring what's going on at the states. And so Republicans have made massive ground at the state level, and states affect like a lot more of people's lives than the national legislation and regulation does. So, especially in things like a post-Dobbs world, like all of the power is at the state level. And we are seeing some positive signs, like a number of states have had referenda about things like abortion rights.
Michigan.
Michigan. That's right. But local stuff matters as well. Like, we all know about all these controversies that are going on at school boards in terms of, not letting children be educated about basic, diversity of sexuality, etc. The problem is, in the US, there's a lot of voting, and so getting people to do it all is really hard. But it's the only tool we have. And what you see here is a big a lot of the focus has been on keeping people from voting. In Australia, we have compulsory voting. Traditionally, there hasn't been this push to stop people, like to have as much focus on, stopping people from voting, because everybody votes.
Right.
And when we had a conservative government, massively decreased the fine for not voting. From when I lived in Australia 25 years ago, it was $100, whatever that would be now, but now it's $20. And so essentially they're trying to undermine one of the great aspects of our system, which is that everybody votes. And you can see the rate of voting going down. In Australia, it's always been about 95% of people vote. Now it's, in the most recent referendum, it was 80 something, like low 80s. And I think it's because it was kind of this decision, same kind of thing, but within this constraint of compulsory voting system, but by making it have less teeth.
It's really interesting to me that doesn't just become a reason for people to vote against conservatism if that's what conservatives are trying to do, is take away the right to vote.
Yeah.
Like, it seems like that is so fundamental that even if we're talking about some of these other things like taxes, etc., like those almost don't even matter, because we can't even get to taxes, because the essential right, the right to vote, it just doesn't make any sense.
It's easy to think, people fought so hard for so long for, particularly African-American people to have the right to vote, and now people can't even be bothered voting. But that's pretty unfair in a lot of ways, because there are so many hurdles to voting. I mean, voting is on a weekday in Australia, and voting is on a Saturday. There are long lines, particularly in minority communities. Like the costs of voting are really high, and that's by design. And so it's hard for people to vote. People have children, they don't have childcare, they have health issues, etc. And there are all these rules constantly being put in place to discourage people from voting and to make it harder. So we have to be careful not to say, people don't bother to vote. I think actually a lot of people, it's true that some people don't bother to vote, but I also think a lot of people, it's quite hard for them to vote, and that's not an accident.
No, but I'm just saying, if we're looking at the two-party system, which I also think is ridiculous, but we're looking at a two-party system, and one is trying to suppress the vote and the other is trying to keep the vote, then why doesn't everyone just vote against the people trying to suppress the vote? Because it's such a basic right.
Because it's in people's interest for some people not to vote. I mean, people can be very, outcome oriented.
I think it just goes to show that we need to put more focus on voting.
Yeah.
Right? Like, we don't talk about it enough. Like, we'll talk about it in an election year, like specifically during a presidential election year. We don't talk about it as much during midterm elections. I mean, the last, maybe couple of cycles, we started talking about it more. Even so, at least as far as my experience has been, is it's still like the policy wonks and the political junkies who are like, yep, it's midterm, gotta go vote, right? Like, it's very, very few people just in everyday life, just Joe Q public, like, isn't just walking down the street thinking, yep, I gotta go vote today. I mean, people aren't thinking about it until somebody like literally puts it right there in their face. And because it's not considered, and this is my personal opinion, I don't think it's considered compulsory. It isn't considered, people don't think of it as, this is a right that people fought and died for. We have to do what we can to make sure that we keep it. People don't think of it that way. Yeah, I mean, maybe that's a little bit unfair to people who have roadblocks literally put up against their ability to vote. But in general, people in this country, just our general populace, not that gung-ho about voting. And there's so many people who aren't even registered to vote when they could be.
It's hard for the ordinary person to understand the extent of the threat. I think it's very subtle. It's subtly masked. So if you look at the way the Supreme Court is whittling away at the right to vote, take the Shelby County decision, for example, that I mentioned earlier, where they ruled that this particular aspect of the Voting Rights Act that previously required states that had a history of discriminating and prohibiting minorities from voting, that they had to get their rules pre-cleared by the Department of Justice to make sure that they weren't discriminating, right? And so the Supreme Court didn't strike that section of the Voting Rights Act down. They just said the particular way in which pre-clearance is approved is unconstitutional, and so therefore we're going to get rid of that and make it very difficult for Congress to pass another check. And so the average person who doesn't read these Supreme Court opinions or understand the complexity of constitutional law and election law wouldn't know that, the Supreme Court just massively opened up a huge door for states that are inclined to do so to discriminate in a way that they haven't been allowed to do for the last 60 years. And then when the states all passed those laws, or every single state that was affected previously by the pre-clearance rules passed rules that made it much harder for everyone to vote. But each one, they'd have their arguments, so they'd purge voters from, so even people who were registered, they'd just purge people from the rolls, and they'd say, it's really important to make sure that there's no electoral fraud, people voting twice, even though there was basically no evidence of that pretty much ever occurring. So it was an artificial problem. But it sounds like a really good thing for government to do, to make sure that the rolls are accurate, right? And so, there's this propaganda war. So each element that you look at to say, here is a way that our right to vote is being chipped away at, you might not realize it if you're not educated to such a level that you understand, what the Supreme Court did, how the states are reacting to that, how that affects people. Like I don't like to be too harsh on the average person who might not, have the information they need to realize that there is this threat. So, and I'm not saying, just, don't worry about it, or, don't exercise. We got to convince people that there is a threat out there, and that they need to vote now so that they can do it in future, essentially.
Right. Yeah. So just, sorry, Jennifer.
It's okay. It's your baby. You've been so excited. You go for it.
I know. I'm just like, Tonja, you've got all of the writing that you do and your column in Bloomberg Law, that people can look to for some clarification and explanation of what's going on with the courts. Are there other resources that people can go to keep up to date with what's going on with the court and have that information be accessible to someone who isn't necessarily a policy wonk or politically minded, someone who just wants to know what's going on in the world?
Right. Yeah. I mean, yes, there are good resources. So SCOTUS blog is a blog that writes about Supreme Court decisions, which cases the Supreme Court is taking. I mean, I think it tries to make them as accessible as possible. Some Supreme Court cases are highly technical and difficult to understand. So, but it has various forum discussions of, especially the really big cases that affect the sort of issues we've been talking about today. There is a great podcast called Strict Scrutiny.
I love that podcast.
Where, four really smart women just tear the court apart for its hypocrisy, its inconsistencies, and it's also just fun and funny to listen to. Nina Totenberg on NPR does reports on particular cases that are, little snapshots that are interesting. There are, Bloomberg Law does a fair bit on the Supreme Court, not just my column, but there are a number of other people with columns about different aspects of not just Supreme Court, but general lawmaking. And that Bloomberg Law, I think, really tries to make things be written. I've had to sort of adjust the way that I write, because I usually write in an academic forum, and I'm trying to write in a way that's explaining things that are more to make it more accessible. And I think my editors do a great job at helping me out in that, and there are lots of columns there. So there are resources where you can educate yourself on these issues. There's a lot out there, and you just have to be careful. There's a lot of junk out there as well. We all know about, echo chambers and fake news and all that kind of thing. But there are reliable sources as well.
Good. Thank you.
In your bio, you said, or Raquel read, that your work has helped to change the court. How has that happened? And what is like your dream or your goal?
So I wrote one of my earliest pieces on oral argument was showing that the female justices are interrupted by both the other justices and the advocates at disproportionate rates, sometimes like 3 times as much in some terms. And this got a lot of attention, and a number of Supreme Court justices have commented on it. In a year ago, the Supreme Court changed the structure of oral argument, partly with a view to trying to combat this effect. And I actually just did a follow-up looking at the extent to which it has been successful in changing, and the results are mixed. There has been some success, but the female justices are still being interrupted by the male justices disproportionately, and actually kind of just as much as ever. But the advocates are actually being much better and being much more even-handed. And the other thing I showed is that Chief Justice Roberts, who I often criticize, for example, he wrote the Shelby case that I've been talking about today, but he has been actually making seemingly a concerted effort to try and combat this gendered inequality. And he steps in, which is what we called for him to do. He steps in a lot more now to give the floor to women when they are interrupted by men, even than vice versa occurs. So, he steps in to protect women's right to be heard, essentially. And so that's a really nice, positive change. So there you go. I'm not just all doom and gloom.
Well, good for him. He's paying attention.
If you could have the dream change that you help create, what would that be?
One of the reasons I do the work that I do, and particularly I do a lot of empirical work on the court, and I try and show the prejudices, not just things like, gendered interruptions, but the sort of things we've been talking about today, the hypocrisy of some of these doctrinal choices that the court has been making. And I think my goal in that is to bring transparency and hopefully a little bit of shame to the justices, who some of them seem a little shameless, to be honest. Like some I think are beyond that. But I think at the more center of the court, which is still very conservative, so Chief Justice Roberts, Justice Kavanaugh, for example, I think they're much more concerned with the respect of the court and the legitimacy of the court than perhaps Justice Thomas and Justice Alito. And I think that, a lot of my writing is directed towards showing when they're being inconsistent, when they're not following basic rule of law principles like, respecting stare decisis, respecting precedent, having rules for when precedent can be ignored, treating different parts of the Constitution as much more important than others. So a lot of my work is directed towards, showing what is going on in the hope that this will raise awareness, so that the effect that I had in terms of gendered interruptions, I would like to have more generally in terms of, showing that the court is harming democracy, and actually not just the effect being that people will go out and vote and, try and change things at that level, but also maybe make people realize that the court is doing harm to democracy, and therefore that will lead to the sort of a response from the justices who care about that. And we're certainly seeing the Supreme Court's esteem is lower than it ever has been since we've been measuring. The court has never been below a majority of support, and now it's usually, even after Bush v. Gore, for example, which was extremely controversial decision, that decided a presidential election. I mean, the support for the court dropped from like 62 to 59%, and people were, oh my God, that's huge, like that's a shock. Now we're down at 40%. That is just in just the last 3 years, and we had this new supermajority that is on the court that thinks it can do things like abolish Roe v. Wade and other rights. That has led directly to this really low opinion of the court. And the court, as we talked about at the beginning, the court was designed to be the weakest branch, and its strength has always lain with its high esteem by the public and its legitimacy, and because it doesn't have the power to self-enforce its decisions. It rests on essentially people respecting the court and following its rules. And it's coming to a point where the justices' decisions have been so extreme, and then it's some of the justices' disregard for the basic ethical rules as well have led to the court being in real peril. And some of them, some of the justices are fiddling while Rome burns. I think they feel invincible.
Yeah, they feel untouchable.
Yeah, and I mean, they certainly are very insulated, but we have not seen this institutional effect play out. There's been talk more than ever about court reform, and not just things like term limits, but packing the court, changing the way in which the court is constituted, and
the size of the court.
The size of the court, and I think that, and also, just bringing in much more stringent ethical rules. And there was talk about this, and Justice Alito actually gave a speech where he said it would be unconstitutional to bring in ethical rules that applied to the Supreme Court, which is just absurd. It is absurd. You can't read the Article 3 of the Constitution and actually believe that. Like, it's ridiculous. Like, Congress has so many powers over the Supreme Court, over what kind of cases it can hear, and all sorts of things. And the idea that the Supreme Court would then strike down rules saying the Supreme Court has to follow ethics rules, like that would be that quantum moment where everything bursts into flames, where the self-dealing got to such a point that people would rebel. I don't know though, but they've certainly, I mean, it's been shocking to me, the Thomas and other revelations, just how shameless and petty this money grubbing is by Justice Thomas in particular. Like, it really is. Generally we talk about appearance of corruption and so on, and I actually that he might have crossed a line away from just appearances as well.
He stomped all over that line.
I felt like I was being controversial there as an academic to say that. We tread very carefully, and you're just like,
not with us.
Yeah, that's
maybe
okay.
with some other people, but not with us.
Yeah, no, we'll just go ahead and say it for you. Yeah, it'll be on me for saying that. That's fine. He stomped all over it.
The main defense that's given of Thomas is, well, he's always going to be an ultra. He's always going to decide everything in favor of the Republicans anyway, so it doesn't do any harm him taking all this money from the Republicans. And I'm like, yes, it does harm to the institution of the court. It does harm to democracy. It does harm to our understanding of what it means to be a judge. Like,
absolutely.
He is just burning things, burning bridges.
Oh yeah, he's burning things down and does not care.
Yeah,
doesn't care.
Yeah.
Well,
I think this has been a great, very cathartic therapy session for us all.
Yeah,
exactly. I honestly, I could talk about this for hours. Yeah, forever. Yeah, I really could, because I mean, this literally just it as I said earlier, chaps my ass, and something needs to be done about it. And with that in mind, is there a process in place where a justice could be removed from the court?
I mean, there's an impeachment process, but realistically,
nobody's
in the current political climate, no. Unless people get out there and vote, and there's a massive change in the political landscape at the moment, no. I think there could be new ethical rules that were passed, but even that, like there's a strong resistance by the Republican Party to doing just that. In terms of actual sort of repercussions for the individual justices who have been flouting the law, like, this is not just rules, this is the law that's being flouted. I don't think there's going to be any repercussions for Justice Thomas. I think he's going to continue doing what he's been doing, and because he's completely politically insulated. But I do think that Congress could do its job and actually pass some more stringent rules, and for the sake of the good standing of the court, to at least stop this particular rot. And I think that is politically feasible. I'm not saying it's likely, but it's possible. Whereas actual punishment for the law breaking that we've seen, no, I don't think there's any chance we're going to see that.
Okay. Well, thank you for being candid about that, because I agree with you. I don't think that anything at this point in our political time that anything will be done to Thomas or Alito. So
yeah.
Was there anything you wanted to share with the audience that we didn't ask you about or you didn't get a chance to speak upon?
I feel like we covered a lot. I do think it's important. This sort of conversation is really important because I do think that the extent to which we talk about this, we educate ourselves about what's going on, and we get out there and vote on the basis of what we learn is so vitally important, more than ever. And so I really encourage people to look into this further. Don't take my word for, what we've talked about here today about, some of these particular decisions. Go to the Brennan Center. That's another, you asked about resources. The Brennan Center keeps a lot of information that makes it's very accessible about particularly things that are affecting democracy. So if our discussion about democracy is of concern to you, have a look at what the Brennan Center has to say. They're a really great resource. And so, and they'll have a discussion about some Supreme Court rulings on these issues as well, and what the consequences have been on the ground in terms of rules that have been passed and so on. And they keep track of like the number of provisions that are written and passed to restrict voting rights, for example, and how many people are actually being disenfranchised. I just want people to, even if our conversation has just piqued your interest, pursue it further. There's a lot out there, and just, go to reliable sources like that, and then encourage other people to do so as well, because I think there's so much terrible stuff in the world. It's easy to feel defeated. We can do things here that affect, that make a marginal effect and that can bring greater transparency and can actually, have the potential to bring reform. So I think this sort of discussion is really important. So thank you for allowing me to contribute. I really encourage people to, if you've been concerned about some of the things we've talked about today, then to continue to look into it.
And thank you for making Raquel's dream come true. She really has wanted to have this conversation for so long. Yeah. And I am so happy to see it happen. And to have you, who know so much, be able to answer these questions.
It's been an absolute pleasure.
Thank you. Professor, thank you so much for being with us and being our expert on this topic, and specifically for giving resources that people can go to beyond just our conversation today. So thank you so much for that information, as well as for the work that you have done and continue to do. So thank you for all of that. You're really very welcome,
and thank you for giving me an opportunity to share my thoughts. It's been a real pleasure.
Well, wow. Raquel, was it everything that you hoped, wished, and did you learn what you wanted to find out?
Yes, all of the things. It was everything that I wanted it to be. We hear about the court, the Supreme Court, SCOTUS, blah, blah. We just hear about this thing. And for people who aren't kind of dialed in, it's just this sort of amorphous, like, whatever, it's over here. They have control over my life. I have no, whatever.
Yeah, I have people like me.
Oh, okay. Sure. It's just like, what's this thing? Whatever. They make these decisions, and then my life is affected, and I have no say in the matter, right? But then to hear from somebody who has been studying the court for decades in a focused and in-depth way, who is saying, this is what's going on with the court, and these are ways that it doesn't have to be just top down. We actually can have some effect on the court by voting, by educating ourselves, by staying aware of what's going on. We have to, I know life is hard and people are busy and people have so many, focuses in their own lives, work, school, kids. I know this is one more thing that we're asking people to focus on, but we're seeing the direct effect of the court on people's daily lives.
Mm-hmm.
And thankfully, we have these references of places to go where we can get the information and it's accessible. So, I'm so grateful to Professor Jacobi for the work that she does, because that's pretty amazing work. And she's keeping them accountable,
Mm-hmm.
right? Which is amazing. And she can then have the conversation about it, and the conversation I felt was very accessible.
Yeah. Agreed.
And then to also give shout outs to other resources. Like she mentioned, the Strict Scrutiny podcast. I love that podcast. Trust me, that is not a dry podcast at all. Yes, they focus on the Supreme Court and they talk about the different cases and stuff. They are very lively. These are brilliant, highly educated women who know how to talk about these cases as Professor Jacobi does in a way that is accessible. Mm-hmm. And, I hear about cases sometimes on Strict Scrutiny that I haven't heard about in the news, because the news gets caught up in only so many stories.
Right.
So, it's an easy way to kind of keep your ears open for what's going on in the court.
Mm-hmm.
But I'm so excited that we've had this discussion today. I'm so excited. I've been wanting to do this for years.
I know.
I really hope that this discussion will prompt people to just take it the next step, right? Like, just like we say on all the other topics that we talk about, don't stop here, right? Let this just be okay, now let me go and learn some more. Let this just be the tip of the iceberg for you, and then go do some more and find out some more. There's ways to get this information.
Yep.
Yeah. What about you?
So for me, I took a couple of notes. A couple things really just stuck out to me, so I'm just going to read them. The first thing, when she said, it's just because of raw political power. Ugh. Mm-hmm. Those are the words I don't want to hear, but that's what I was hoping wasn't true. Raw political power. That's why these things are happening. The court is harming democracy. It's probably going to be our episode title. The low opinion of the Supreme Court. The invincible Supreme Court. These things, to me, actually, they have me bummed out a little bit.
Yeah. Very frightening, actually.
Yeah, bummed out.
Very frightening.
Raw political power. Political power.
Yeah.
I guess I'll just leave my thoughts on that, because I'll be thinking about that for a while. Yeah. Raw political power.
Same. Thank you, Jennifer, for
I'm so happy for you.
my little nerd heart. My little nerd heart is so excited right now. It just literally grew 3 sizes.
I knew you were going to say that. Bye, Raquel.
Bye, Jennifer. Thanks, everyone, for listening today. We will be back with more Madness Cafe next week. You can find us on Instagram at Madness Cafe Podcast, or email us at madnesscafepodcast@gmail.com. Bye.